Good morning and welcome to today's webinar, which is the third edition of the Latvian Wind Energy Academy. And today we will speak more about the initial stage of wind farm development phase, and that is legal mechanisms for securing the land. An important topic for sure. The topic will be covered by our two brilliant speakers, Viktorija Cherkas, who's the attorney at law and partner at RockBridge Legal, and her colleague, Nataļja Golubeva, who's also a lawyer at RockBridge Legal. And yes, and my name is Lasma Līvziniece. I'm the executive director at the Latvian Wind Energy Association. Now, the plan for today is to have two presentations. All in all, that will be around 40 to 45 minutes, and then the remaining hour will be dedicated to Q&A session. So if you have any questions right away or questions arise during the presentations, do type them in the chat box, in the chat section of the Zoom window, and we will address them after the presentations. Yes, with this, I finish now and give floor to Viktorija. Please go ahead.
Lasma, thank you for your kind introduction. Dear all, I'm happy to welcome you to a webinar of the Latvian Wind Energy Academy. Today, we embark on a journey through the legal landscape of first stage of a wind farm development, securing the land for the project. We will give some structure and insights of the options available. Let's move straight forward and delve into various types of access to land for wind farm development. Let us start with identifying these forms. First, and the most safe way to secure the land is to purchase it. Although it is not preferred form for wind farm project, but as I will mention further, it is mandatory form for some part of it. Second, construction right agreement, or agreement on right of superficies, as you prefer to name it. This is the only available form of agreement that is now used for registration of ownership of buildings that is constructed on third-party land. What to include in such document and what to think of before signing, it will be a topic to discuss today. Third, land lease agreement. Can we forget about it, or is it still a form to use? We will discuss it. Fourth, servitude agreement or easement agreement, as you may prefer to name it. What are the main differences between servitudes and construction right agreements? That's another topic for discussion. Finally, a consent, namely a written permission of the landowner, when it is used and used at all. Now, let's look into peculiarities of the mentioned options in more detail. Let's start from the first, acquisition of title to the land plot. So first, purchase of land. It's not the most appropriate and most common form in wind farm development for a few reasons. First, it's more expensive, as all the property has to be acquired, sometimes divided, as developer, of course, is not informed about the exact part of the property which will be required for wind park development before he has actually completed the research stage. Secondly, only small part of this property is actually used for placement of VTGs, and the rest remains available for other use. However, if such option is being evaluated due to any reasons, please pay attention to limitations and conditions precedent to such transactions, like the ones set to acquire the agricultural land or forest land, checking whether the specific purchaser can acquire the land at all, what are minimum permissible areas if this land plot has to be divided before acquisition, as well as evaluate the risk of right of first refusal that is applicable to agricultural land. To make this long story short, you have to make a legal due diligence before you actually acquire the land and think of proper structuring of this transaction. Possibly think of buying back it later if it appears that land cannot be used for wind farm project, for example. And when you're almost sure that this purchase of the land for wind farm is not your way to go, it's worth mentioning that for building a transformer substation, it's required that part of the land plot, together with the respective transmission system operators part of the substation, is transferred to the TCO. Therefore, at least one land plot will need to be acquired, so don't forget the proper legal due diligence and remember to check minimum area requirements of the respective municipality to divide this land plot and pay attention to exemptions there too, which mainly appear in respect to engineering buildings. So construction right agreement is option number 2, or agreement on granting rights of superficies. In simple words, since 2017, construction right agreement fully substituted the former lease with right to construct. From a legal perspective, construction right is a property right granted by agreement to build on a foreign land plot. It's important to note that construction right agreements are made only for construction of non-residential buildings or engineering structures. The term for it, at least 10 years. The construction right is usually being established for the entire land plot. If you have agreed to establish it only in respect to part of the land plot, then first you have to separately measure and register this area that you are willing to acquire with the cadastral, with the construction right. And please note that by this action, you are not actually dividing the land plot in parts, you are only registering the area to be used for construction. It is common for wind farm development to firstly get all the area of the land plot at the research stage and then adjust it later on to the area that is actually required for construction only when the project clearly defines the placement of the VTGs. Sometimes it's along with the receipt of the construction permit, sometimes it's at the moment when the design project is fully approved by the municipality. Construction right is established and effective as of the registration as entry in the land register. Please pay attention to the form of registration. There may be an entry as a form of registration or a notation. In Latvian, it's ieraksts and atzīme. The entry is the one that actually grants construction rights with all the consequences provided to the construction right by the law. A note, however, it's just a notification about sign agreement that due to specific circumstances cannot be registered as an entry. And with registered notation, you cannot rely and consider that you have construction rights sufficient to perform the construction works. You only have a notation that is sufficient until the moment when you do not have any more obstacles not to register the entry. Construction right also can be alienated, it can be encumbered if otherwise it is not prohibited in the agreement with the landowner. Also, the parties may agree on right of first refusal and redemption. This is not provided by the law automatically. Also, after the construction right agreement is terminated, buildings become an essential part of the land plot. Thus, the owner of the land plot will automatically become the owner of the constructions after the term is ended. If the price is not specified in the contract, like price of compensation to the landowner, then to the construction right holder, then according to the law, the landowner acquires buildings without any compensation to the construction right holder. Now let's dig into some specifics of the construction rights agreements. First, pay attention whether you are dealing with private or public land. In respect to public land, there are specific rules that you have to follow. Among the most important topics is auctions to acquire the rights of construction, the maximum term of the agreement, which is set at 30 years, as well as remuneration calculations, which you have to comply with. Construction right as such grants to its holder exclusive right to use the land in the area as determined in the construction right agreement. Exclusivity goes along with the responsibility for the same area, because the construction right holder, as the exclusive user, becomes responsible for the land that is transferred to him as determined in the construction right agreement. Exemptions of this liability should be agreed in the same agreement. So in case if you're willing to agree with the respective landowner that they are continuing to use the remaining land plot that is not needed for the wind farm, it should be specifically included in the agreement, as otherwise it's not allowed. The land plot is provided for your exclusive use. Only during the duration of the construction right agreement, the construction right holder holds ownership over the buildings which are registered in the construction right in the land register. And here, please note the public and private regulation, because the ownership title is valid only during the term of the agreement. And as mentioned before, in case if you are dealing with the public land, this term is more limited than in cases when you are dealing with the private land plots. Another concern to be raised because of the buildings, may be raised because of the buildings already existing on the land plot. There are some opinions that you have to take all the area except for these buildings, so then you have to make some measurements before registration. However, Supreme Court has confirmed that construction right may be registered over the land plot where there are already other buildings situated and owned by the landowner. So in this case, you do not have an obligation to separate these buildings from the construction right area as long as they actually are needed for the construction right holder. But please note the responsibility topic related to holding exclusive right over the area mentioned in the construction right agreement. So it means that construction right holder also takes the responsibility for all the actions that are being performed in the respective land. So if somebody is suffered because of this building not properly upkept and nothing regarding this liability division is actually included in the construction right agreement, then it might be risky, of course. Another topic is remuneration. It can be agreed very different as a fixed fee, as percentage of income, different mixed possibilities, caps on both sides, as well as amount depending on project maturity. One amount may be set in the research stage, another amount in construction stage, and a different amount may start applying when the wind farm is being operated. All of that is with the exception for cases when you are again dealing with the public lands. There you have very specific regulation, as already mentioned before. Also, provisions on exit or termination of construction right agreements is a topic that should be very specifically evaluated and correctly addressed before it is included in the agreement. Moving to the next option, which is land lease agreement. Again, from 2017, a lease agreement is not used when construction on land is planned. To be even more correct and specific, construction as such is allowed on third parties' land. But in this case, the construction right holder, or the one that is leasee with the possibility to construct, will not be able to register its title to the building. Thus, all that is constructed by such leasee automatically becomes part of the land and thus is transferred to the landowner. So it's not considered as option for a wind farm as such, but in some cases where it's necessary to use additional land for the construction process, for different storage options, this lease may be sufficient. So lease agreement can be appropriate for construction period, for land plots that you use for temporary construction works as a storage area, Also for example, existing access roads that might be used for material supplies or for storage or for placing the equipment, materials. For all these purposes, the lease agreement still is an option to use. Next one that we have to review is servitude or easement agreement. For construction of certain parts of the wind park, like engineering networks or access roads, an easement agreement appears to be even more suitable than construction right agreement. An easement or servitude is the right to a limited use of someone else's real estate. For example, right to use road on third party's land to access the VTG. What makes construction right agreement different from the servitude is the term. As in case of servitude, it's usually not that highlighted, and in most cases, the servitudes can be established without the term. They can be established in two forms. The servitude may be as a real servitude, which is established in favor of another property, like access road to specific property. And it can be established as a personal servitude, meaning for the benefit of a specific person, like for the benefit of the construction right holder. Which one of these options to use is up to developer to decide, but both of them are available. Most of the other rights, also servitude, is subject to registration in the land register to ensure that the third parties are informed about it, and you can use all the rights that are granted by servitude deriving from the law. In some cases, servitude rights would allow common use of specific serving property with other parties. For example, if you use a servitude road to access the wind farm, then also some other parties may be granted the same servitude right, meaning that also maintenance and repair works can be performed by all the users altogether, as you are not exclusively responsible for that particular road. Some additional legal points in respect to servitude agreements. Specific use. Servitude provides a specific right to use the land for very particular purposes, such as installation of engineering network where use of particular access roads is very specific. Secondly, servitude provides legal security and clarity where construction right does not. If building or engineering construction is not subject to registration as per cadastral law, for instance, network, or in some cases also access roads may not be subject to registration, then having a servitude agreement will ensure that your right to use the land for this particular purpose are publicly registered with all the consequences that it provides. Simplicity. An easement or servitude may not be, as already mentioned, exclusive, and also servitudes are related to a very definite part of the land from the very beginning, and they are provided for very specific use. Therefore, it's generally easier to agree with the landowner to establish it, and the servitude agreements do not involve the same level of legal complexity and limitation to the landowners as construction rights do. And finally, the cost effectiveness. Due to mentioned simplicity, servitudes are more cost effective for the developer compared to construction right agreement. A written permit, that's an option number 5, and that is such approval of the landowner that may be drawn up as a contract, as a separate consent, or the landowner's signature on the project with a disclaimer as to what exactly the consent is being given. If this form is used, you should always keep it safe, at least decide to use the agreement instead of any one-sided unclear approval, which later on may be amended or not confirmed if repeatedly required or otherwise at risk. This is the most less regulated form of all the above described, and we cannot foresee all circumstances when the right to use the land may be limited or terminated. Also, it's not adaptive to various circumstances that may appear during research, development, or operation stage. Also, it is not publicly registered. Some of the most common risks that can be mentioned is, for example, expansion of networks, amending designs of the wind farm, changing of the landowner. In all these circumstances, it will cause certain risks, whether you should request a new consent or you can use the previous one, to what extent you can rely on that, and all the related topics that lawyers may face. Since we have covered the land use possibilities very generally from a perspective of legal forms, let's move to a more detailed list of the issues to remember when preparing any of the above documents with the landowner. So there are some topics to evaluate when you are reaching the agreement with the landowner. First is area. When planning the wind farm, you have to be very clear and specific on what area you need, on which conditions, and when this area may be amended, decreased, adjusted, whether any amendments of this area should be coordinated with the landowner, or you can perform these amendments on your own, or you have to coordinate only the roads or only the placement of the VTGs and how the connection roads are going together with the existing road network, and on what circumstances these amendments are prepared. You have to think of use of remaining land that you will not need for the infrastructure, especially in respect to the construction right agreement. Use of land for agricultural or livestock needs should not require detailed regulation. With forestry, you may prefer to have some additional provisions about territory around the VTGs. However, for more risky topics like hunting, you may prefer to have some more strict regulation and liability provisions. Any limitations, any allowances should be very clear. If nothing is mentioned in the construction right agreement, it means that the construction right holder has exclusive rights over all area included in the agreement, along with the full responsibility to upkeep this area safe. Deforestation. This topic is mentioned separately as deforestation of land near the VTG and roads may require clear provisions. Should the construction right holder or the landowner be the one to organize and be responsible for this deforestation? For some companies, it may be a material topic because some of the landowners are holding FSC certificates, and it's material that deforestation is performed by themselves. However, if deforestation is performed by the construction right holder, you should include regulation regarding whose income is capital received from the sale of wood. Also, requirements during any development phase of the wind farm, for example, installation of the wind mast, another access road that can be used for some specific period, deforestation of specific area, storage places, area for placement of the cut food or construction equipment, and other terms that may be material only in respect to some stage of development that also is recommended to think of and possibly include in the agreement with the landowner. What is not included is not agreed, and later on may appear that it might be rather difficult to agree on. Next topic is safety zones. Although they are not valid, as legally they are cancelled, but the safety rules remain in place. And you have to keep in mind that everything that you would like the landowner to do or not to do should be included in the agreement, or at least right of the construction right holder to set the rules later on. Drones, their use in the forest, for example, deforestation provisions, construction of network or buildings by the landowner, installation of any additional equipment on the same land plot close to VTG. What are the activities that are allowed in the nearby area of the VTGs? These are just the first topics that come in mind when speaking about the safety provisions. Then what is actual engagement with the community and neighbors? What is approach of the construction right holder? What are your particular activities to ensure that project is accepted by local community and by neighbors? Maybe applying some specific procedures, maybe some coordination measures, maybe some limitation in respect to activities of the wind park that can be provided to the landowner. Just think of this. Engagement of the landowner during the project development. You should evaluate its amount and risks related to such approvals, especially in cases when landowner may change and current mutual understanding that you have with the landowner may disappear. So you have to have very strict rules on cases, on circumstances, and on actions, how you correlate with the landowner, and what happens in case if the landowner is not accepting any of the documents that it has to approve during the development stage. You should also think about addressing the risks that are relating to existing network and possible findings during the process of construction, like unexploded ordnance or inheritance that may appear, as well as responsibility for the possible pollution that might appear and which is not related to the construction right holder. So once more, the beloved topic of the lawyer's liability. Address exact provisions. Who is liable for what and on what conditions, and for what not? That also should be specifically mentioned. Land restoration to its original in the end of term of the agreement. Special provisions recording the existing status to know what is the original condition, and address the issue about the built infrastructure. Evaluate and agree whether some of it can be left in the property or even must be kept in the property, like access roads. Maybe there is no need to demolish them. Thus, we have reviewed the forms of possible use of the land and discussed the topics to be evaluated. And now we can make some final note how to combine these options and what to consider when comparing them. Let me assume that any wind farm project is always a combination of several kinds of agreements with landowners, with a specific type of agreement for a particular land plot. Depends on several factors. For instance, if we speak about the VTGs and any other buildings, engineering constructions that are planned on the land plot, especially the ones that can be registered in according with the cadastral rules, then option to buy the property is number one, or the second is to conclude the construction right agreement. These are the most appropriate and the most safe for this part of project. For substation, as discussed, currently acquisition of the land is the one to use. Some amendments may follow to construction right agreements depending on owner of the land, but let's keep on the safe side. If we are speaking about only engineering networks that are planned on the particular land plot, then purchase, of course, can be used, but not the common and most efficient form. So in this case, the servitude agreement will be the one that is the most appropriate. For some specific cases, also the consent, especially considering that the servitude and consent usually may not have the terms. So in cases if you decide to prolong later on the wind park, you will not have to address each and every agreement where you have only network placed on the land plot. For building permanent access roads, if they cross a separate land plot, then again an easement agreement could be the most advisable form, although all the mentioned forms are also possible for construction of access roads. For land required during operation or only of some period, for some period of development or construction, it of course can be a consent or a land lease agreement. So which form of legal agreements to use and which is the more secure for a wind park developer, the choice between the construction right and servitude agreements ultimately depends on specific circumstances. The lease agreement and permit is not an absolute no-go. As discussed, all can be used if risks are weighted against benefits. So all of that should be somehow reasonably balanced, as we may say. Having said this, I say thank you for your patience and attention, and I give word back to Lasma and move to next tax topic related to the landowners. Thank you very much.
Thank you, Viktorija. Yes, the topic is rather complicated, I would say, but this is not it. We have another speaker coming up, Nataļja Golubeva, who will speak more on the tax peculiarities that may arise in relation to making payments to the landowners. And before I give floor to Nataļja, just a quick comment. Well, at least to me, I saw the presentation in a bit blurry manner, so if you had the same issue, don't worry. Those who registered for the webinar will receive the PowerPoint afterwards, so stay tuned, so to say. And yeah, with this, Nataļja, the floor is yours. Thank you.
So thank you, Lasma, for introducing me, and let's jump into a text section right away. Given that today we're talking about starting deals with landowner, it would be very essential to talk also about reviewing a deal from a tax perspective. Before starting engaging into a deal, there are four main questions that should be asked to the landowner in order to understand what tax consequences could raise for tax risks could raise when dealing with such a landowner. The first main and essential question that needs to be asked, who is the landowner, in which position the landowner wants to be engaged in this deal. Does he wants to be an individual in the individual's position or as a company? When the developer deals with a company, there are less risks, less tax risks, because the company by itself should understand and declare the transaction, and it is its responsibility to pay taxes. But when the deal is with an individual as a landowner, then there are some risks that could raise, and therefore in my presentation I will talk more about individuals and less about companies. And this is the first question. Regarding second question, it needs to be asked if the landowner is an individual. The question is the landowner registered as self-employed person? About this question and about risks that could raise, we will talk later. And such kind of status of person needs to be checked by using link that is attached in this slide. And the third question is the landowner a VAT payer? This kind of information needs to be checked by using the link in this slide. And the fourth question is also regarding individuals who is not registered in State Revenue Services as a self-employed person. The question is, will the payments exceed 50,000 euros per 12 months? And if we talk about the landowner who is individual, it is essential to understand that the land tort rental is business activity. And therefore, a landowner individual needs to be registered in the State Revenue Services. And according to this, what I mentioned before about individuals, it is understandable that you could ask the question, why should I know and understand and obtain this information about individual? Is this individual a self-employed person or not? It is essential to understand that if the person is not registered as a self-employed person, the tax payment obligation lies on the developer. Therefore, it is essential to understand whether this individual is self-employed person or not. And therefore, we can jump into this section when we understand is it in which situation the landowner could decide to become self-employed person, or only to notify economic activity and pay 10% from revenues. It is, of course, it is the individual's responsibility and obligation to understand what is more appropriate to them, but as but here we can only describe the main difference. If the person, if individual decide to become self-employed person, then this person is obliged to pay personal income tax and social security contributions from the difference between revenues and expenses. In case of notified economic activity, personal income tax of 10% is paid only from revenues, excluding expenses. Therefore, the person can decide which is the best solution for them, or and register themselves. But there are also could be a situation when an individual is not a self-employed person, or does not notify economic activity. In this situation, the developer also is obliged to pay taxes from this income payable, and thus this is very important to understand, and this question is the main question to ask an individual. And what else should be considered regarding declaring and withholding personal income tax from payments to self-employed, not self-employed person, but individuals who is who has notified economic activity or not registered at all. The developer needs to declare payments, of course, made to an individual, and the developer is obliged to pay personal income tax to the state budget. And it is necessary to point out that the personal income tax needs to be withheld not only from payments, but also from not only from this lease payment, but also from VAT, which is calculated and made to an individual, and also from deposits, which is not considered as value-added tax object, but it needs to be also calculated and withheld. This personal income tax needs to be calculated and withheld from deposits paid to individual with notified activity. And regarding the question, is the landowner a VAT payer? It is necessary to understand that the land lease is considered as a transaction subject to value-added tax with standard rate 21%. And therefore, if the landowner is VAT payer, the developer is entitled to deduct input VAT and include it in their VAT returns. And therefore, it is also necessary to understand, is the landowner value-added tax payer, and will the developer and should the developer include this payment in VAT returns and deduct input VAT from these transactions. And the status of a landowner could be checked by using the link in this slide, and therefore when it is when it comes to VAT payer, then if the land plot is used for transaction subject to VAT, the developer can deduct input VAT in their VAT returns. And if we are talking about notified economic activity and VAT, it needs to be mentioned that according to Latvian VAT law, if the total value of taxable income during 12 months is 50,000 euros, the person needs to be registered as a VAT payer, and deposits in this context are not considered as taxable income. And therefore, if the transactions, land lease transactions during 12 months exceeds this kind of amount, 50,000 euros, that then it needs to be highlighted that the landowner need to be registered as value-added taxpayer. And in case of notified economic activity, as it was mentioned before, the developer must withhold personal income tax not only from these lease payments, but also from calculated value-added tax. The question that could be raised related to this situation, but what if an individual does not register themselves in the VAT registers when the transaction amount exceeds 50,000 euros per 12 months? Of course, VAT and late payment interests lies on an individual, but to avoid any risks that these VAT problems and risks comes to developer, it is advised to provide in the agreement that the lease payment includes all taxes applicable, and it is the final amount payable for this transaction. And yes, that's pretty all from my side. And if you have any questions, please do not hesitate to ask them, and we will try to answer to them during this webinar. Thank you very much.
Thank you to Nataļja as well. But now this is the possibility to ask questions, get them answered. Can I also ask to bring on the screen? Yes, Viktorija and Nataļja as well. Great. So there were a couple of questions that came in before the webinar, but before we get to those questions, I do have a question from my end, because it has been a topic for a couple of our members. And yeah, I guess it's addressed more to Viktorija. So what risks do you see in registering the construction rights as a note instead of an entry in this land register? Because it can be confusing.
Indeed, Lasma, it can be confusing, and as mentioned, only the entry the right to consider that it is a construction right without the consequences that derives from the law. But at the same time, we see that some public institutions, for example, when they are granting these construction rights by the agreement, they are setting that the first moment when you are entitled to register the construction right as an entry is only after you have actually approved the design. But at the same time, in the parallel world, we also have some different rules that are more related to, for example, receipt of the permit for installation of new powers. And in that case, there are now different discussions with the responsible authorities about how to actually consider this statement in these regulations. Should you have registered entry, or it's enough to have a note at the moment when you apply to receive this permit for installation of new power? Hopefully, we will have this clarification on broader understanding that this particular topic can be moved forward with receiving just a note in the land book, because at the end, the state authority has to check only the fact that there is such an agreement about installation of particular wind farm on that land plot, and all the creditors have made their confirms on this side. But let's see how it will end. But if you have a choice, then of course recommendation is to have the entry from the very beginning, and then just by rules of the agreement make specific provisions to adjust this area, to agree on the liability topics and possibility to use this land while you are not actually building the wind farm, but you are in the research stage. So that all should be included in the agreement. But if there is a choice between entry and note, then of course it's an entry.
Yeah, I guess it's also it might be confusing also for the landowners, right? Because they tend to be more cautious when it's an entry, because it kind of gives them more obligations for a longer period of time.
Indeed, they at that moment they may get a bit confused, because as mentioned, the construction right is something exclusive that is granted fully to the developer for the whole territory at that moment of research, and then it gives some possible unclarity for the landowner, and how I will be able to use it for agricultural or forestry needs, what are the conditions, and what this exclusivity actually means in practical terms.
Okay. Right, thank you. A question to Natalia. So, you described various options regarding applying taxes in different models, but if the landowner is a payer of a micro tax, or in Latvian we call it mikronodokļa maksātājs, what difference does it make, if any?
Thank you very much for the question. In case if a landowner is paying micro enterprise tax, from the developer perspective, such landowners should still be treated as a self-employed person, and thus the payer of the micro enterprise tax should declare income by themselves and pay the tax independently.
Short and sweet. Thank you. And then there is another one. Like this is, I guess to Viktorija as well. So if a developer constructs wind farm on the third party's land, can you go with the servitude? What is the relationship there?
Here is that very important note about what you are able to register as your title and what not. If we divide the wind farm in, so to say, several parts, then in respect to VTGs, you should use the construction right, because VTG is something that you will be able to register in the land register as the cadastral object. However, in respect to network, for example, which is something that is not being registered nor in the land register nor in the cadastral as a specific building, then in respect to these type of objects, you should preferably use the servitude agreement and, of course, ensure registration as servitude as such in the public registers, but not the object that you are constructing based on the servitude agreement. So you just have to divide all the wind farm in parts and then apply different provisions considering that particular situation that you have.
Okay, thank you. Nobody seems to be willing to ask any questions here in the chat box. Either, two options, either everything was perfectly clear or people are simply too afraid to ask the questions, but that's fine. That's fine. Hopefully everything was clear. Yeah, I mean, how do you, Viktorija, think is Latvia specific in terms of land registration if you compare it to other countries? Is it somehow more difficult? This is maybe asking on behalf of the foreigners here.
Well, it differs from topic to topic, but in essence, in places where we have this specific regulation in respect to development of wind parks and use land for this development, like we have the amendments to the public land use, where we have included regulation in respect to use of this public land specifically for the wind park, we see that to some extent the legislator has gone a step forward on one side, including this registration, but at the same time the rules are so strict that for some developers it's rather difficult to comply with them, and then the developer chooses to go with the private landowner because there is an option to agree on more different rules of cooperation. But if we compare the complexity or risks related to development, then of course there are some small or larger topics to consider, and I presume that such topics are in other states, just we have them a bit different, but of course everything has to be properly planned and you have to be aware of them in the beginning, and that's the reason why at the moment when you start development you have to know the main risks and main topics to include in all the documents and to think of. That is also the point where we are specifically stating the importance of planning, the importance of knowing the view of the wind farm as such, so that you can include everything from the beginning, and that's not coming as a surprise at the moment when you start the construction.
Yes. All right, thank you. So with this, since there are no more questions, I'd like to thank everybody and remind that once again, we will send out the presentations. The recording will be available on the Latvian Wind Energy Association's YouTube channel, but we will also make sure to just drop a link to you as well. And yeah, we will continue with other topics. Well, I guess I can't promise this month, but definitely next month. And we will try to cover, the idea is to cover the whole development process, and we will have different interesting topics as webinars. But stay tuned. We will let you know when the next webinar is planned, scheduled, and what the topic is. Yeah, with this, I'd like to thank the speakers and the guests, and see you next time.
Thank you.